Good evening, everybody. Thank you ever so much for joining David and I for this evening's Autumn Series seminar. It's the business crimes session this evening. We're talking about the evolution of business crime post-COVID. We are genuinely delighted to welcome so many of you this evening. I'm also genuinely delighted to be able to welcome David Stern, who has hot-footed it here this evening from Prospero House. He's in the middle of a trial as we speak. As I'm sure most of you know, David and I are the joint heads of the business crime team, but ironically this is the first seminar that we've ever been able to do together, and it just seems odd that we are doing it by way of a webinar and not in the same room, but nevertheless we are pleased to be able to do it together, and I say to welcome so many of you. Sadly, I suspect that all of you are now very familiar with the way in which Zoom works. We're going to be talking about a number of topics, but we're keen to make it as conversational as we can. And so please do ask questions either via the Q&A facility that's at the bottom of the, I think at the bottom of your presentation, or via the chat button. And we will try and answer as many queries as we can as we go through the seminar. So with no further ado, I'm going to hand over to David.
Thank you, Sarah. And it does feel a little bit odd to be doing this via Zoom, and in particular when we can't actually see any of you. So I do have a sneak preview of how many of you are there, and many of the names of whom people I know, and for those of whom I don't, a very warm welcome. We normally have quite a nice social gathering after these sorts of events, and unfortunately we'll have to do that in spirit rather than be able to be there in person. We are going to talk about sort of three main areas this evening. The first is my favourite topic of CumEx, and I know some of you on the call will be very familiar with this as a topic, and others it might be a new area, but I certainly see this as an enormous growth area for the sort of work that we do, and we'll explore some of those issues and some of those opportunities. It's definitely not a European-only problem. There are many issues that relate to the United Kingdom and London in particular, and we'll discuss some of those and also give a bit of a primer about what CumEx is all about. And then Sarah's going to take the lead on COVID fraud and the new opportunities that arise out of that. You know, many of those will involve terminology that we didn't know about a year ago, furlough fraud, and all these sorts of things. And so that's going to be of interest. And then the final piece of the evening's entertainment is sort of two almost interrelated topics. The first is the opportunity to engage with prosecuting authorities, potentially in a different way to the way in which you might be used to doing that since the onset of COVID, and the impact that that's had both on prosecuting authorities and the criminal justice system more widely. And then finally, sort of hot off the press, as it were, and as Sarah was saying, the last month I've been enjoying the delights of Prospero House, which is, for many of you will know, the extension of Southwark Crown Court, where there's three courts there which are handling fraud trials at the moment, and we're able to successfully handle multi-handed fraud trials which involve defendants who are on bail. And we'll talk about some of the interesting issues in that sort of post-COVID world, both from a practical sense and some interesting theories that we have, and also some latest news of what happens if and when someone in the court room that you're operating from might come down with a suspected COVID-19 infection. So without further ado, let's turn to the first topic of CumEx, and let's look at what I hope doesn't fill you with total horror, which is what on the first blush might look like a rather complicated figure. But I thought if I put this up, it would allow us to work through some of the basics of CumEx. Now, CumEx is a relatively complicated dividend arbitrage stock trading scheme, and in short, I came across this really after the LIBOR trials had all ended, and was looking for the next thing that might be of a similar interest. And the big distinction between LIBOR and CumEx was in LIBOR, we didn't have any really perceived victims. There were no provable losses involved in any of the LIBOR cases. But in CumEx, it's the very least, and I think I can say that, you know, with some certainty, around 55 billion of losses in euros that were taken from the treasuries across Europe from the implementation of these stock trading practices. And of course, for many years, these were carried out by large financial institutions, no doubt with legal advice, and no doubt thinking that what they were doing was a perfectly legitimate part of a trading practice that allowed them to take advantage of certain loopholes that existed within the tax regimes of those European countries, such as Germany or Denmark and many others. And what this figure tries to demonstrate in brief is the nature of that trading and how it came about. And so you see at the top there, that's where it says state. And by that, I mean the European country, if you like, the treasury. And down at the very bottom on the left-hand side, it says D-Day, which is no pun intended. In fact, that's supposed to be the dividend day. And that's when, and I've given an example of a German company, let's say Mercedes-Benz, pays a €10, I should say, gross dividend to its shareholders. Well, what actually happens, as you see in the line above the D-Day box, is that the net payment, the net figure, and in this case, 7.5 euros, I've given as an example, goes to the shareholder on the record date. And the WHT figure, which is the far left-hand arrow that goes up to the state, that's the withholding tax. And that's a feature that's not known under English law specifically. We don't operate that system in the UK, but it's a system that's operated quite universally across Europe. And so Mercedes-Benz in this example would pay the 2.5 euros to the German Treasury. And you might think, well, that will be the end of it. No fraud there, or no even suspicion of tax evasion, because the state's got its withholding tax, all well and good. But if A is, for example, an offshore entity, he's entitled under the general taxation treaties to ask for a refund. And so that's why you see the shorter arrow down from the state saying 2.5 euros back to investor A. And again, if that was the end of the matter, we wouldn't be talking about CumEx. But what if the stockholder A decides to either sell or loan its stock or share shortly before the record date to another party, in this case, party B? And so B either borrows or purchases through a stock loan, either through a stock loan agreement or a stock purchase agreement on very standard forms, standard market forms, no problem with that at all. And then B then ends up entering into another transaction with another investor, C. And what happens in that final transaction, and as I say, this is done on a very large scale, and this is really simplified, or trying to simplify this process, is C is basically paying not just for the ex-dividend amount of the share, but he also pays what could only be described as a manufactured payment, which would include the amount of the withholding tax that was paid to the state, in other words, the 2.5. So it looks like C's actually paid between the record date and the settlement date for the full purchase price of the share, including the gross dividend amount. And what that entitles C to do, as you can see on the chart, is to, through a variety of features, a custodian bank would be persuaded to believe that C was the legitimate, at very least, economic owner. When economic ownership of shares is an interesting concept, again, not really known under English law. We have legal owners and we have beneficial owners. But he would then reclaim that 2.5 euros back from the German state. So as you can see in that scenario, the German state didn't actually get the 2.5 euros because it paid it out to A, who is, say, an offshore investor. It's also paid it out to investor C. And C could do that because the custodian bank was prepared to issue a certificate which purported to show that he was effectively the holder of those shares and was entitled to the withholding tax reclaim. Now, if that was done on an industrial scale, and I use that term not pejoratively, but the figures you can imagine we're talking about with a $55 billion loss is going to be significant. But that's not the end of it, because what you see there is some arrows going back from C, so the top line between the C box and the B box. The share, of course, goes back. There's a forward sale, which means that the ultimate holder of the share at the end of all of this process is still, in fact, shareholder A. And so shareholder A actually still ends up back with his original share. But the state, unbeknownst to it, has paid out the withholding tax twice in this example. And after a while, the German state got rather fed up with this and decided to try and close that loophole through a number of measures which it's done, and is now pursuing rather aggressively a number of individuals and a number of institutions. And so if we can turn over to the next slide, please. We can see from some of the issues that I'm about to talk about that this is not just a German issue or a Belgian issue or a Danish issue, because the convictions which took place in March of this year, which were against two bankers, Mr. Shields and Mr. Diabel, and also involved a significant fine against a German bank. That came in March, and it was pretty clear from that, and also in relation to a tax decision that was made in the tax tribunal, that the German courts no longer view this as legitimate tax avoidance or taking proper advantage of a loophole, but have now been persuaded to determine that this is in fact tax evasion. And there are many investigations ongoing, and there were about 400 at least letters that I understand were sent out to suspects, in part because of a limitation issue that had been identified by the German prosecuting authorities. Primarily, there's a 10-year statute of limitations between the date of the offence and the date of the investigation. And so by issuing the suspect letters, that effectively put a hold on the statute of limitations from running. And so quite extraordinarily, those number of letters were sent out. And there are, as I understand it, at least 100 financial institutions involved in this. And some of those might be obvious, well-known household names, some less so. But they are facing, obviously, a potential significant risk and exposure. And each of those corporations, whether they might have been the brokers involved in some of the trades, whether they're the financial institutions running the dividend arbitrage desk, they will be conducting internal investigations. They may well be responding to the FCA, which has its own not published investigations, if that's the right way of putting it. As many of you know, it's hard to find out exactly what they're doing, but they are acting, and we're being told to expect some announcements soon from the FCA. Although we note that in February, Mark Stewart was saying it was imminent. So I'm not sure imminent's the right word, but they are getting there, I'm told. And then you've got obviously the potential risk of either existing employees or former employees who are potentially going to be dragged into cases in Germany and potentially elsewhere. You've also got the potential issues relating to what I've put in there as MLA requests. So the German authorities and others have been seeking through MLA requests issued in their jurisdiction and are sending those requests to HMRC predominantly, and they're effecting search warrants in this jurisdiction seeking to obtain the raw data that underpins the trading and the transactions that took place. And that involves significant amount of work, whether one might be responding to the search warrant to the then ongoing discussions between HMRC and one's particular client regarding whether the documents respond to the request, and that can take some years to resolve, which of course can be to one's client's advantage. There are others involved in the process. I've just seen a question pop up there saying, would I consider the money laundering aspect of tax evasion part of this? Short answer is potentially yes. I'm not sure if that's driven towards a UK offence. Obviously, one of the issues I looked at when this came up was the application of the Criminal Finances Act. But of course that applies to the evasion of foreign tax as well as UK tax. But of course the start date for that postdates all of this trading, so it doesn't apply. So the short answer is there are no, as I understand it, criminal proceedings in this country at the moment, but money laundering quite possibly could be part of that equation. The next topic I touched on there is extradition from the UK. At 5 St Andrews Hill, although not part of our seminar tonight, we have a very strong extradition team, and we've been instructed in a number of current extradition requests from the United Kingdom to other jurisdictions, and I can't really say much more about that at the moment, but that's another obvious growth area. There are future trials in Germany that are both ongoing and due to start quite soon. And if one is thinking about all of the variety of issues that exist, in all of the cases that I'm involved in, there's both a local criminal defence team and a UK defence team responding to providing representation to those individuals. And some of these cases involve the usual D&O issues with insurers, because many of the financial institutions, you'd be unsurprised to know, would have had good D&O cover to respond to that. Of course, I touched on briefly before the response of the United Kingdom authorities. That's primarily likely to be the FCA in the first instance, but I am aware, just from conversation on a conversational level, that the SFO is certainly aware of these ongoing investigations. Hasn't, as I understand it, got a dog in the fight at the moment, but if you're starting to see DPAs, for example, on a European scale, then you might see that the SFO will become particularly interested, given the sort of direction of steer that the SFO is operating under at the moment. And then finally, I talk about internal investigations and compliance. Clearly, the first thing that any financial institution should be doing if it's got the potential for CumEx exposure. And by that, I pretty much simply mean, does that particular financial institution have a dividend arbitrage trading desk? Because it may not know whether it was carrying out CumEx trades or not, but if it had a dividend arbitrage trading desk, it should certainly be well advised to be having a look at its historical trading practices. From a compliance point of view, of course, there is the ongoing duty under the Criminal Finances Act to have these reasonable measures in place, these protections in place, to have taken every responsible measure and safeguard. So there's an awful lot of work to be done in that area as well. So yeah, when I first sort of set off to do my research and become more heavily involved in the CumEx cases, a few people were saying, well, this is really going to impact the UK. And I said, I really think it will do. And we know that because, for example, Denmark, which has gone down a different path, has not started criminal proceedings. It's gone down the civil route. There is very, very substantial litigation, both in London and in New York, in which the Danish authorities are pursuing a number of allegations in the civil sphere. And my understanding is that a significant part of that may be part of the evidence gathering that they will then seek to utilise later on in some criminal sphere. So watch this space. It's ongoing. It's fairly fast-paced. And for those who want a more detailed analysis, I'm going to do a little plug on CumEx before I leave on an article that was published in Butterworth. But because I was the author, I'd be happy to send it to anyone who wants to read it and have a cure for their insomnia this evening after their hopefully well-earned glass of wine. So without more from me, I will pass back to Sarah now.
Thanks, David. Mine's a little bit more straightforward. I'm going to be looking at two aspects, really. Firstly is the fraudulent activity that is already arising and is already being identified in relation to the various government schemes that have been introduced over the past few months. And then I'm going to touch on relatively briefly the predicted fraudulent activity that's likely to happen in the future as we go into the inevitable recession that's going to come on the back of COVID-19. Moving on then to the next slide, Tess, if you can, thank you. It was inevitable, really, that given the speed at which the government introduced the various schemes to help employers and the self-employed at the very start of lockdown, as I say, it was inevitable that they would give rise to fraudulent claims because they were rushed through, understandably so, but without sufficient checks and balances being in place and introduced at the outset. Sadly, some of the figures are eye-watering in terms of the scale of the estimated fraud that has been committed. For example, in relation to the furlough grants, HMRC estimate that up to 3.5 billion, or somewhere between 5 and 10% of the grants that have been made have been fraudulently or mistakenly claimed. The first arrest in relation to these schemes was made back in July 2020 for an alleged claim of £495,000. And as you all know, other more recent arrests have been made. I'm going to focus, if I may, on the furlough scheme as part of this aspect of the talk, because it does appear at this stage that is the one that is being, that's the government's focus in terms of the one they want to investigate. HMRC are going to be the ones that are focusing upon the investigations in relation to this scheme, not least because they were the one that responsible for dealing with it, and it was also the most widely used and expensive of all the schemes that was introduced. We're all familiar with the general idea of the furlough scheme, or to give it its formal title, the Coronavirus Job Retention Scheme. The idea being that employees were paid up to 80% of their salaries to be kept on as employees, but provided, of course, that they didn't actually work. As I say, it was administered by HMRC, and they are going to be the ones that are investigating it. At the end of July, obviously of this year, that the Finance Act that was introduced then introduced a 90-day period for employers to declare that they might have overclaimed a CJRS grant, which they had not repaid. And they had 90 days from the latest of the following to make that declaration. After they received the grant, secondly, after the circumstances had changed so that the employer was no longer entitled to keep the grant, and thirdly, and probably most significantly for where we are today, in any event by the 20th of October. Now, if an employer has made the declaration, then HMRC can recover the full amount by way of a tax assessment, with payment of that amount being due within 30 days. But of course, the issue now is that the latest possible date for that self-declaration has now passed. So what that means, of course, is that HMRC, if they now discover that an overpayment has been made, they can issue a penalty. And it may be, so looking at the sanctions, it may be that companies start coming to you for advice in relation to the penalty that has been levied by HMRC. Now, when it comes to assessing the penalty, HMRC will take account of what the employer knew and when, but significantly, that the starting point is that if the employer knew that it was not entitled to the grant, or knew that it stopped being entitled to it because the circumstances had changed, and it didn't notify HMRC before Tuesday, so before the 20th of October, then the statute says that HMRC may treat that failure to notify as deliberate and concealed, which means that a penalty of up to 100% of the grant may be charged. So it follows perhaps that those who have not self-declared before Tuesday could be facing large penalties. Apparently, according to HMRC data, they have identified 27,000 what they regard as high-risk claims that are being investigated, of which 8,000 of those have come to their attention via the furlough fraud hotline. It's not hard to see that there are going to be disgruntled employees who have been asked to work whilst furloughed, can see how they will be keen to use this number, particularly if they are then made redundant by the employer. But in addition to the levying of the penalty, there is, of course, the possibility of prosecution, and that is where we may come in. Because if HMRC take the view that a case is too serious merely to levy the penalty, then they can obviously make inquiries with a view to prosecution. Now, examples of furlough fraud are no doubt obvious. They can include, for example, claiming funds for fictitious employees, claiming funds for employees yet requiring them to work, or putting the funds that were obtained towards a purpose other than wages, tax, pension, or national insurance contributions. What about the likely offences? Again, no doubt obvious to most of us. If the employer is an individual, then one potential offence is cheating the public revenue or fraud by false representations. Now, if the employer is a corporate, then there is, of course, the possibility of the strict liability offence of failing to prevent the facilitation of tax evasion that was introduced under the Criminal Finances Act 2017. Significantly, of course, knowledge or active involvement by senior management is not required for the prosecution to prove this offence, and the only defence in law is to have reasonable preventative procedures in place. Other offences, of course, that may be considered by the prosecution is money laundering, particularly by those in the regulated sector. For example, accountants acting on behalf of companies that may have handled the company's furlough grant money and have inevitably had a suspicion that fraud had been committed. As I've already indicated, it's going to be for the HMRC to investigate these cases before making a charging recommendation to the CPS. Now, if one of your clients is subject to investigation in relation to this offence, or indeed in relation to the levying of a penalty, some practical solutions or practical ideas that you may want to think about in terms of advice to the clients is obviously firstly to review their records, make sure they have got detailed decisions documented in relation to claims that were made. If any disgruntled employees have complained in relation to being asked to work, again, ensure that that has been properly investigated by HR or whoever is responsible within the company. And then, as Dave is going to come on and touch upon later, it may be worth engaging with HMRC from an early stage in relation to these matters and considering offering repayment of the grant money as part of that ongoing negotiation and early engagement with HMRC. Turning then to other schemes, and in particular the bounce back loan, because that is another major avenue of fraud that seems to have been committed. Again, as most of you know, the Chancellor issued nearly £35 billion in bounce back loans to help 830,000 small and medium-sized businesses. The idea behind the scheme is it can help a business borrow between £2,000 and up to 25% of their turnover, up to a maximum of £50,000. Now, obviously, as with any loan, it has to be repaid, but no fees or interest is charged for the first 12 months. Now, the first arrest in connection with fraudulent claims made under this scheme was back in August. The investigation so far has revealed that a number of mule accounts have been used to receive the proceeds from fraudulent applications to the scheme. A number of account freezing orders, interestingly, have also been made in relation to this particular fraud. Now, notable really about this scheme is that prior to the arrests, a number of anti-fraud organisations and white-collar crime experts had raised significant concerns about the potential loss to the public purse as a result of claims under this scheme. And you may recall that back in June, the Evening Standard published a letter that had been written to the Chancellor highlighting the potential for abuse under the scheme. The signatories to the letter included the former director of the SFO. And notably, the letter urged the government to be more transparent and publish the names of those companies who had received the loan. The Treasury responded by saying that the scheme had offered a lifeline to small businesses, and therefore, any fraudulent applications would be criminally prosecuted. Again, it's not hard to see examples of the sorts of fraudulent applications that could have been made. Firstly, for example, false representations being made in relation to the turnover of the company, which governs, as I said, the amount of loan that was received. The inherent problem, arguably, with the whole scheme is that limited checks have been done. And so much like the mortgage frauds that we all saw back in the late 1990s, a lot of the applications have effectively been self-certified. And so it's not easy to, it's easy rather to envisage circumstances where offences under Section 2 of the Fraud Act are going to arrive in this situation. Other possible frauds include claims being made by third parties on behalf of a business without, in fact, the knowledge of the real business, or indeed organised crime groups intimidating businesses in order to obtain loans and then steal the money. I've included on this slide other schemes, just by way of an aside, really. Again, some of you may have seen that in relation to the Eat Out to Help Out scheme, it was reported a couple of weeks ago that a franchisee of Papa John's was being investigated for having claimed £250,000 under the scheme for non-existent meals. I've put that in there really to show how widespread the frauds that have been committed on these various schemes has been, and is going to be revealed, I'm sure, in the next months and no doubt years to come. Turning then to the second part and looking perhaps to the future, although this does in fact touch upon some of the risks that businesses in particular are exposed to now. As I said, it seems inevitable, and a number of commentators are clearly already identifying this, that we are going to be regrettably facing a major recession as a result of the impact on the economy of COVID. And again, regrettably, history suggests that there tends to be an increase in the commission of fraud when you have an economic downturn. I think it's quite interesting. Others may disagree, but the reason for the increase in fraud during economic downturn has been explained by reference to something called the fraud triangle, which the three corners have been identified as being opportunity, motivation, and justification. So, for example, opportunity is where you have a systemic weakness. Motivation is clearly desperation, which has increased in times of recession, and justification can be deriving from a sense of entitlement or indeed dissatisfaction. It's not hard, as I say, to see how the existence of all of those factors gives rise to fraud, and how those factors are more likely to exist during a period of economic downturn. But what also tends to happen when you have economic downturn is that usually follows a bull market that itself may have been fueled by fraud. For example, you have companies who have been fraudulently obtaining too much credit on the back of overstated profits. And so effectively you have this perfect storm as a recession starts, of the frauds that are coming out of the bull market coupled with the frauds that are being committed during the recession. And then of course in the current circumstances, that combines too with the frauds that have been already committed under the various government schemes that were hastily introduced. Now, a number of commentators have highlighted that as we enter this particular recession, it is the opportunity corner of that fraud triangle that is particularly prevalent. And that is largely because of the increase in remote working and also because compliance budgets have been cut, which brings with it obviously both internal and external risks to a business. Now, internal risks derive from disgruntled employees who may have access to company funds and who don't feel as scrutinized or supervised as they would if they were physically based in an office. But it's the external risks that are particularly heightened at this time of remote working. There has, for example, been a notable increase in the number of phishing frauds and cyber attacks. It's not entirely clear why, but one theory is that people are logging on via their home Wi-Fi, which may not be 100% secure. They're using communication tools that are not secure. They're decreasing the regularity with which they change their passwords. And psychologically, they're not as engaged when out of the office, hence the increased success rate of phishing frauds. It's no doubt obvious, but if you have corporate clients who are concerned in relation to the fact that they may be potential victims in the current circumstances, they would be advised to have a look at the websites of the Fraud Advisory Panel, the FCA, and in particular the National Cyber Security Centre, all of which offer fairly good guidance, practical guidance in relation to reducing the risks that are faced by businesses now.
There's another, Sarah, is another sort of aspect to when you have these huge economic pressures, that frauds come out of the woodwork a bit in a downturn, because you've got people desperate to get hold of their investment returns, which might have been perhaps overinflated through Ponzi schemes. Certainly that happened in the last financial crisis. And then if you've got these sort of enormous economic pressures, you know, the other strains that you might see are just, it might happen by happenstance. And the LIBOR cases were really out of the financial crash. You know, they came about really because you know, people were starting to look into a particular type of behaviour that the spotlight just wasn't on before, this LIBOR benchmark. So I guess the headline for all our, I hope still our listeners that we still have at this time on an evening would be that we've got some real opportunity for increased work that's going to ultimately come out of what has clearly been you know, one of the biggest crises that we've ever faced.
Yeah, agree entirely, David, agree entirely.
I think it's back to me now. Engaging with the prosecution and news from the front line. Just to break those two down for a second, engaging with the prosecution is really to touch upon the potential opportunities and dangers that might exist with engaging or taking that approach. And then news from the front line I'll come on to discuss about the trial. But if we could look at the next slide. Engaging with the prosecution, I think for many of us, having much detailed interaction with prosecuting authorities prior to charge would not be seen as something that we would really do. Counsel, for example, would rarely get involved in a typical criminal investigation until charge, and indeed solicitors might be quite cautious, hoping perhaps that the least said, the soonest mended. A particular investigation might just stay at the bottom of the pile and eventually nothing might happen. So what are the opportunities that COVID has created to engage with prosecuting authorities in a different way? I mean, firstly, we now know that COVID-19 is to be considered a change of circumstances. That's true whether you're looking at a bail application, but it's also true if you're looking at the public interest test and potentially the evidential test that the Code for Crown Prosecutors that applies to all prosecutions in this country. Both public, obviously, in terms of the public code, but even private prosecutions have to go through the same process. The next sort of aspect of it is that we've got this sort of unprecedented challenge to both prosecuting authorities and the court system. I think you all know or will have heard about the tens of thousands of criminal cases that are sort of piling up against the backlog, and the fact that they're taking a fairly long time to sift through. We also know that prosecuting authorities that are operating largely remotely can be struggling to move their investigations efficiently and effectively. The SFO, which is a very large organisation in terms of the way in which it wields its powers, really didn't carry out much in the way of Section 2 notice interviews during the crisis, and very little was happening in relation to charging decisions for many, many months. And then we started to notice that in part as a potential crisis response, or just a coincidence, that a number of quite significant investigations were being dropped, like ABB was an SFO investigation that was dropped on the 19th of May in 2020, sort of right in the heartland of the COVID crisis. What changed? We know that the SFO has recruited a particular individual to improve their reaction to compliance and the speed at which their cases are dealt with. But we know that the backlogs are increasing. And then Lisa Osowski delivered an online presentation to the symposium which takes place every year up at Cambridge, which unfortunately didn't happen this year, but she very kindly delivered her webinar. And in it, she was talking about having a laser focus on investigations and increasing the pace of investigations. And we noticed that with a couple of actual charging decisions that the SFO has made recently. But what are the engagement strategies that you might want to think about that might be different or slightly unusual to the ones that we were doing before? And I'll give a not entirely hypothetical case, but one that I obviously can't mention the name of, where the investigation's been going on for 5 years. Nothing's happened, bar a few interviews and a huge amount of paperwork being created, no doubt. And clients don't like to sit around for years on end, not knowing what's happening to their case. And if there is an opportunity to engage with prosecuting authorities, and of course, we all know that in corporate speak, cooperation is considered to be a considerable advantage if you're, for example, trying to negotiate a DPA. But we're beginning to see, particularly with HMRC investigations that Sarah touched on before, a willingness to achieve a civil outcome where possible. And that might be to considerable advantage of a particular client in a way which they might not have wanted to engage before. We've also seen that there's been positive reactions to engagement on fact-specific cases. Each case would have to be considered on its facts, but whether you might wish to engage with a prosecuting authority seeking to lay out the ground rules as to why the case will never reach the evidential test or the public interest test. And it's a carefully balanced exercise because you may not wish to provide all of the weaknesses to a prosecution's case to allow them to shore it up. However, there may be strategies in particular cases where you can look at weaknesses that are going to be inherent whatever the outcome of the case. And in one particular example I'm thinking of, it might be expert evidence. And we've seen a willingness from both clients who are privately funded and indeed those that are being funded by D&O insurers to provide proper budgets to actually do a deep dive into the case. Now that might involve obtaining early expert evidence on a particular issue. It might involve hiring external investigators yourself to try and understand what evidence is there or may be there. and it might be hiring investigators that might wish to go to open source material, for example, so you can have a better understanding of what the case is to come. Now, if your client does get charged, then some clients are actually keen to move the process on and get on with it and not have the sword of Damocles hanging over them while this backlog goes on for the next 2 or 3 years. So it may even, in any event, speed up the process so that you can actually get to court and get some justice. So each case will be fact specific, but I spoke anecdotally to a number of colleagues to see whether it was just me thinking that this was a good idea in certain cases. And I can certainly report back that in a number of cases, a number of law firms and their external counsel are adopting similar strategies to try and bring their case to a swift conclusion in the right case, or maybe even to a swift charging decision. And sometimes charging decisions are to your advantage. And I'll give you the example of someone who might be facing a prosecution in the United States of America, or one who might be facing a prosecution in the UK. And I think we all know we would rather be tried. If we were running a contested not guilty trial, I would say almost invariably you'd rather be tried in the UK. So you might wish to speed up the process simply to avoid some sort of further future extradition proceedings. So lots of ideas, I hope, about why the current pandemic does create opportunities to engage with prosecuting authorities in ways which might have been hitherto seemed an unlikely course to adopt. And with that in mind, let's move on to literally hot off the press. As Sarah said, I've just got back from Prospero House. I've been there for a month. It's not been a lonely exercise, apart from my junior, who's also from Fife St Andrews Hill. We had 2 other teams operating in the 3 courts that were all operational as of until a couple of days ago, more of which later. And so we've been having socially distanced contact, but that's it. I shall be proud to report that that hasn't impacted any of us. But what is Prospero House like, you might wonder? I wondered because I'd never been there before. It turns out that Her Majesty's Court Service have really, really worked incredibly hard to produce a court out of nothing that is a little bit like a cross between a hotel and a conference suite. And it's got 3 relatively large courts with socially distanced jurors, which makes for some interesting changes of approach. In our case, for example, the QC's moved to the back row because of where he's sitting. It just allows him to have a better line of sight to the jury. It's incredibly clean. There's a team literally going around, a bit like painting the Golden Gate Bridge. You start at one end and carry on painting until you get to the other and keep going. And it's spotless, and I'm immensely proud of the work that they've been doing. We've been given parking spaces in a London Crown Court, which has made it immensely pleasurable to come into court. And instead of having a shoebox of a room with my Nespresso machine backed up against some files, we've each got sizable conference rooms to manage our work up there, and an entire floor devoted to us. But do book early because there can be difficulties depending on the number of cases in there and the number of defendants. So in brief, it's been a real pleasure. But my next bullet, and I'm going to only take the credit for this on a theory because I hadn't realized that this might be underpinned by science, which Sarah's going to help explain in a moment. But it occurred to me, in part from a conversation I had with a prosecutor from our chambers in another case, that juries were less interested, shall we say, in the criminality that was being presented before them. And my theory was, well, it doesn't really feel like a criminal court. It feels more like we're in a civil court. And we're all having discussions about potential fraud. In the case I'm dealing with, it's a significant tax case involving large sums of money, but big companies, corporations, thousands of employees. It doesn't really have the feel of a criminal court. And part of the reason for that must come from the fact that it doesn't have a dock. And so you don't have your clients sat in a dock. You don't have any dock officers. It really does create a different environment. They're all sat with their solicitors' teams in a different part of the room. although still visible to the jury. In a case which I'm told there was overwhelming evidence, shall we say, verdicts of not guilty were returned, causing some surprise. So I'm going to just briefly hand back, if I may, to Sarah to actually underpin my theory with a bit of science.
Yeah, thanks, David. There's actually a very interesting 2015 report published by Justice about the impact of having a doc on the jury, and the fact they are less likely to convict if the defendant is sat effectively in the well of the court and not in the dock. I would say it's worth reading, even as and when we come out of this situation, because there is some merit in asking for your client to sit in the well of the court with you in an ordinary fraud trial, for example. A lot of research that underpins the report is based upon Australian and US experience, and in particular appellate cases in Australia and US, which take into account the fact that the defendant was sat in the dock at the time he was convicted. It's worth a read. So it's 2015 Justice report. It's easily available online. But it's interesting that, as you say, with your knee-jerk reaction from being at Prospero House, that it is underpinned by a lot of research that's been done.
Thank you for that, Sarah. So I touched there on what the experience for the prosecution and the defence and the advantages and disadvantages. Some of that's come out in the discussion about the jury point. But I think, as I say, for the prosecution, it's quite hard to get that flavour that we're actually dealing with something incredibly serious that may involve the loss of liberty or a conviction against company directors or whatever it may be. And you could see that when the defence cases started in our trial. Suddenly there was sort of an attempt in a theatrical sense from the Crown to try and sort of bring the jury into the fact that, you know, certain defendants might be lying or might be being economical with the truth and so on. And it really sort of felt like it was falling on deaf ears in this enormous room that was socially distanced with not the usual sort of, you know, measures of justice that surround those court buildings. Of course, one of the potential disadvantages or difficulties is just how do you get your points across to the jury? They really are spread out, and I'll come on to at the end to questions where I've seen an interesting point raised. But so you're talking to or cross-examining your witness who might be on one side of the room, and your jury is significantly far away. And so how do you get everyone to be on board? And you also might have solicitors, for example, attending by CVP. So we have a CVP link, depending on whether your solicitor can be down there or not. So I think that's a real advantage, because depending on how you're funded and the measure of remuneration, it does allow your solicitor to take part in the proceedings without actually having to travel across London with whatever difficulties that may involve and any risks that may involve. So it's been, frankly, a pleasure. And as I say, I think the advantages are more to the defence for the reasons underpinned by science as well as theory, and the disadvantages are mainly for the Crown. So I suppose that's a bit of good news. Let me deal with two bits that aren't so great, potentially. One is the COVID secure rules and the impacts that they have on a trial. So obviously there's the usual hands, masks, hands, face, space, whatever the latest guidance is that we all have to do. But so far as documents are concerned and the impact on trial, it was a much more complete process and task that we had to engage in the pre-trial preparation stage. We effectively needed to know each and every document that we might wish to put to any particular witness. We had to consider which way the evidence might turn and how we might respond to that, because we had to have our jury bundle caught 72 hours before the trial started, effectively with everything in it. Now, in reality, that hasn't been the case. We've brought new documents in. We've tried where it's all possible to leave 72 hours between having them printed and being deployed. On other occasions, we've been able to put things perhaps on the digital case management system and use it that way. But you really have to, it's not just the 72 hours, it's, as I say, the fact that you have to do much more detailed preparation, both with your client, but also in terms of preparing the documents you might wish to deploy in cross-examination. And that means you need to have counsel who've got the time to do that, because it certainly was much more time-consuming in the preparation than it would normally be. And then finally, what happens if someone tests positive for COVID-19? And a couple of days ago, when I walked into court, I got my key, was heading up to the elevator block, or lift block, I should say, not in America. And I saw 3 blokes in a hazmat suit spraying down the doors of Court 1. And it turned out that one, and I won't go into detail about it, but someone in that court had suspected COVID symptoms, which I believe have been confirmed. And as far as I know, that court is now not operational, and I'm not quite sure yet, but when I checked this morning, it still wasn't back up and running. So I don't know whether there'll be an impact on the trial itself, whether it will still run or not. And I just see a latest update from one of our members of Chambers who says we should be back on Monday. So I think that might be a straight week off. But of course, that's going to impact how a jury will remember the case, which may be to a defence advantage potentially. But also, let's be realistic about this. There will be cases this winter across the country which will be started and may not be able to finish. And that might lead to not just the disruption for all parties to the case, wherever they may be, whether it's witnesses, defendants, lawyers involved in it. But of course, it may mean that the Crown gets several bites of the cherry. So one of the things I would say is that while we had our jury bundle at court, we did not share it with the prosecution. And we've been quite sensible about when we deploy documents, because we don't want to reveal our hand any quicker than we need to. So on that note, I would say if anyone's got questions, please feel free to add them to the chat room. We'll do our best to answer them. And I've noticed that the hour that I think allotted is nearly up. But I hope that shows that there's a lot of opportunities that are going to flow from what has been a very, very difficult year. So that should be an optimistic note to end on.
Thanks, David. There's been an interesting question asked in relation to how receptive the SFO and others have been to attempts by one suspect to shape the narrative. You're probably best placed to deal with that, having had some experience of that.
Yes, I can. It's a very interesting question, and I think what underpins it is the thought process that if you've got a wieldy investigation involving a large corporation, say, and perhaps say 10 or 15 directors down to managers, maybe even lower than that, can one individual really shape the outcome? And I think to think that through in a couple of ways. Firstly, you might be wishing to shape the outcome to suggest that a DPA actually, in fairness to everyone, is the likely outcome. And as most of the listeners will know, a number of DPAs have been entered into with companies where there have been no subsequent prosecutions of any individuals, notwithstanding that the DPA itself may refer to conduct which might be so considered to be so. I think of Rolls-Royce, for example. And so that could be one thought process that an individual could have to shape the flow of the direction of travel. Another is that you might wish to be involving yourself with other defence teams. Depending on the nature of the investigation, you may well know who the other individuals are and how they're being represented. So you might wish to, for example, get your first bite of the cherry in, if you think that's the right way to go, depending on the facts. Would depend on whether that was the right approach. But you might also then wish to share as a concept with other defence teams, not the detail of it, but just the concept, and that they might wish to be thinking upon similar lines. And certainly in one of the cases that I've been involved with, we've had a broader discussion and the thoughts that underpin that with other defence teams as to whether they're not really a coordination of approach, but just nothing's happened for several years. This seems to be an opportunity. Is it something that another person or another team might have considered? So the short answer is, I wouldn't discount it, even if you're one suspect in a multi-handed investigation, because there's a number of issues that come into play here. Funding is a big one. And take the SFO as an example, it has limited funding. It can go and seek further funding for particular cases, but it is very much going through this laser focus that I talked about and trying to up the ante and up the pace on its investigations. And if you can move one to down the tree or to getting rid of, therefore it'll allow them to focus on other cases that might be more to their benefit. And I think it also really depends upon the type of case. Are we talking about something that really might not be viewed as criminal conduct at all in the cold light of day, or are we looking at something that really is a very, very serious fraud with grave consequences for particular individuals, in which case you might not be wanting to take that approach at all. So I hope that answers that. I can see one other question up here. And thank you to the questioner for her response. That's very kind. And I think it was in relation to the jury point, and comes in from, I hope I can give credit to this to Mr. McNamara, who's also down in Prospero House, and he says that he thinks that the socially distanced nature of the jury, as well as them being without the docks and all the rest of it, that the fact that they're socially distanced and being kept very separate means that they don't have an opportunity to feel together. And so that he thinks that may have an impact as well. I presume positively from the defence point of view, but I'm sure he'll tell me if that's not the case. So I think there's some good reasons to be wanting your trial to be in Prospero House. I think that's the conclusion that I've come to.
Thanks, David. I don't think we have any other questions, unless there's anything else to come in.
No, I just see that John McNamara has responded saying positively. So my first thought was right. So that's a good note to end on. But I would just like to say, I'm sure Sarah will wrap it up, but just like to say a very big thank you. We know that there were a lot of attendees tonight, and it really does make the hard work that Sarah and I put in to put this together really feel worthwhile. So we really, really look forward to seeing you very soon. And if anyone wishes individual chats on CumEx or anything else, we'd be delighted to do an in-person or in Zoom or anything else that we're allowed to do. So we wish you all a very good evening. Thank you very much, everybody, for attending. We've enjoyed doing it, even though we have been doing it via a webinar rather than in person. And as David has said, and I can reiterate and echo, if you have any questions, please do contact us individually or via Dave Scutton, our Chambers Director. But thank you once again for giving up your time to spend it with us. And I think on a final note, I think we will be either posting on our website or be able to send out the slides that we've done, and I think there'll be a recording for those who couldn't make it. So if you wish to share it with anyone, I think there'll be a way of doing that. And I'm sure you'll all get an email from our marvellous Director of Marketing, Tessa, who's really helped put this all together from a technical point of view and a practical point of view. So a big thank you to her as well. Thank you. Thank you, everybody. We'll see you all very soon.